What is a receipt and release form? That's the question I'm answering today. I'm Aaron Hall, an attorney in Minneapolis, Minnesota. When there is a trust in place for an estate plan, and the person who owns the trust has designated money go to a beneficiary, when that money goes to a beneficiary, the best practice is to have them sign a receipt and release. So typically, a lawyer will draft a receipt and release form which says money is going to this beneficiary, the beneficiary is acknowledging receiving that money, the beneficiary is releasing the trustee from any liability in exchange for receiving this money. Let's talk a little bit about what does that mean. Well, the first part there, the beneficiary acknowledges receipt of the money. There's nothing complex about that. It's just having a written receipt that, all right, I got $50,000 from a trust. The second part is more important. The trustee is the manager of a trust. The trustee is the one who writes checks to the beneficiaries. So the trustee manages the trust and makes sure money goes to the people who are supposed to get it. Well, when the trustee writes a check to somebody, it's a best practice for them to ask that person to agree not to sue the trust later, and to agree that, hey, in exchange for getting this money, we're fair, square, we're even, nothing further is owed of you. And so that's what that release does. It's simply the beneficiary acknowledging, in exchange for getting this payment, I release you, trustee, as in case anything, errors or other issues may have arisen. What we don't want to happen, and what this release accomplishes, is we don't want the beneficiary to take the money, go hire a lawyer, and then sue the trustee for more money. So that is why the best practice is when a trustee is issuing money to a beneficiary, the trustee requires that the beneficiary sign a receipt and release. They acknowledge receipt of the proceeds, and they release the trustee of any legal claims that may exist, so both parties can move on and not worry about the threat of a lawsuit later. Now you might be wondering, what if a receipt and release wasn't signed? Well, there's probably still evidence of the receipt because there's a cash check, presumably. But what about the release? Well, the beneficiary technically did not release the trustee from claims. So the beneficiary could turn around and sue the trustee and say, hey, I'm owed more money or something, or you did something wrong. So that is the risk that exists when no release is signed by the beneficiary. I'm Aaron Hall. I'm an attorney in Minneapolis, Minnesota, and if you're interested in more information like this, you can see the link to aaronhall.com in the description below. If you have other questions, feel free to add them in the comments section. And if you'd like more educational videos like this, you're welcome to click on the subscribe button. Also, please note below there is a disclaimer simply explaining this is an educational video, and I do these videos so you can spot issues to discuss with your attorney, not as a replacement for hiring an attorney. Thank you.